Good afternoon. Please be seated.
It's a housekeeping matter.
All right. Well, let me take care of first things first that I got to take care of first. So, one thing in housekeeping, there was a thumb drive that was presented as evidence in the Spencer hearing this morning. And let's record reflect states present, defense counsel, and defendant present. You can be seated. Has that been submitted to the clerk?
It has not. I was considering it as a demonstrative aid to the court. If the court prefers that I file it, then I will. I've got it in my pocket.
I think it was made part of the record and referred to, so I think it's been identified. I would
May I
just.
approach the clerk?
Yes. All right, and when we left at the end of the Spencer hearing, the defense indicated they had further argument and potentially wanted to talk to Mr. Wilson about presenting anything further regarding the Spencer hearing.
We don't have any further evidence to present. The court can inquire of Mr. Wilson if you would like, but he has elected not to provide any testimony in his defense.
So at this time, the defense does not have anything further regards to the Spencer hearing.
We do not, Your Honor.
All right, is that correct, Mr. Wilson?
Yes.
Okay. Anything else from the state?
No, Your Honor, thank you.
Okay. Then you did indicate you had some argument in regards to sentencing?
I do,
All right.
but we need to approach.
Okay. And as per the sidebar, I know Mr. Wilson didn't approach, but waiving his ability to be up here at the sidebar. And I'll just say what was said, that basically this morning we had the Spencer hearing. At the end of the Spencer hearing, defense counsel indicated they may have further argument and wanted to speak with Mr. Wilson regarding any other potential testimony. We recessed until 2 o'clock this afternoon. And so the court came back in to see if there was any further evidence or testimony, which appears there's not. And if there was any further argument regarding sentencing. Subsequent to that, I will take another recess, and then we'll come back for the court to issue a sentencing order at that time. So that's procedurally where we are.
Yes, sir.
Okay. All right, so is there any further argument then?
Oh, yeah, do you want to be at the podium?
Yes.
Judge, briefly, you've heard all of the evidence, the testimony in the case. On behalf of myself, Mr. Hollander, Ms. Perez, Mr. Wilson, we want to thank you for your consideration of Mr. Wilson's sentence in this case. We understand that when a jurist takes the bench, you hope you don't have to make a decision like this. But we know that Your Honor has paid close attention. You've considered the law, you've considered the facts, the evidence, and you're going to render the decision that you think is just. Obviously, it's either sentence is a terrible sentence. The sentence of death is worse in that if there is a mistake along the way and we can't correct that mistake, we can't correct the sentence after it's imposed. We'd ask that the court consider The 3 statutory mitigators: the capacity of the defendant to appreciate the criminal nature of the conduct or to conform that conduct to the requirements of the law was substantially impaired. Obviously, you've heard testimony that he consumed quantity of controlled substances. He described it to the officers, said it basically made him almost insane. Defendant requires specialized treatment for mental disorder that is unrelated to substance abuse or addiction or for a physical disability, and the defendant is amenable to treatment. We don't know what kind of treatment that's going to be on death row. We know that he needs treatment. There's testimony to the fact that he's been on treatment. He's been on the same treatment throughout his stay in the Department of Corrections and in the Lee County Jail. He needs that medication. He needs that treatment. Defendant cooperated with the state to resolve the current offense or any other offenses. I'm sure the court recalls that Mr. Wilson provided a statement to law enforcement. At the time he provided the statement, he was not aware that they had located the second victim. He was doing that in an effort to assist the victim's family. They had already located the second victim, but he didn't know that. He provided them with details that, but for his statement, they would never have known. We have non-statutory mitigating circumstances. Defendant was born to drug-addicted teenage parents. The defendant's biological mother suffered mental illness. Defendant's mental illness presented at age 12 and was precipitated by puberty and substance abuse. Defendant was diagnosed bipolar disorder and I call it schizophrenia. It's a little bit different diagnosis. Defendant is loved by his adoptive parents, Candy and Steve Wilson, who has provided a statement to the court. Defendant is loved by his sister, which was reflected in the statement read to the jury. Defendant was profoundly affected by being abandoned by his biological parents. He's been a loving son to his adoptive parents, as reflected in the statement read earlier today. I remind the court that the jury's recommendation was 9-3 for one victim and 10-2 for the other. Under their previous statute, that would have required this court sentence my client to life. Likewise, I would remind the court that Mr. Wilson has been waiting trial for a long time. The unfortunate death of his previous counsel prolonged the litigation and impacted Mr. Wilson greatly. I point out to the court, lastly, obviously the court has received, and I know that you haven't read them because I have received notification from your office that these letters have been received by your office, but I know that the court would not read an ex parte communication, that the letters have been sent back to us, but obviously there are people that have been pleading for Mr. Wilson's life and for the court's mercy. There are some 40,000 people that have signed petitions to that effect. We'd ask the court to take into consideration that death is permanent. Death is different, and we're asking the court to impose 2 life sentences for Mr. Wilson.
Steve.
Good afternoon, Your Honor.
Good afternoon.
I'd like to point out, and I agree with defense counsel, that death is in fact permanent. Christine Melton was 35 years old. Diane Ruiz was 43 years old. Both of their deaths were permanent. Back in June, when this court heard the facts and circumstances of this particular case surrounding the deaths of Ms. Melton and Ms. Ruiz, this court should have learned that this case was nothing more than power, control, and violence that led to murder. Mr. Wilson's decisions were not only pitiless and consciencelessness, but they amounted to tragically reducing Miss Melton as well as Miss Ruiz to nothing more than memories and photographs to not only their families but also to their friends. The only reason why that happened was because they both encountered Mr. Wilson. The state, back in July, went ahead and prepared a sentencing memorandum for the court to consider. The reason why the state did that, Judge, was because the state wanted the court to be aware and point out specifically the facts and circumstances supporting the aggravating circumstances and factors that the jury considered in this particular case, and that the jury specifically found proven beyond and to the exclusion of every reasonable doubt. Specifically, the jury is the one that found that Mr. Wilson was previously or contemporaneously convicted of another capital felony or of a felony involving the use or threat of violence to the person. That particular fact, an aggravating factor, was established throughout the course of this trial by virtue of the verdict that was rendered by this jury when they found Mr. Wilson guilty of both counts of first-degree felony murder and first-degree premeditated murder. Secondly, Judge, the jury found beyond to the exclusion of every reasonable doubt that the capital felony was committed by a person previously convicted of a felony and under a sentence of imprisonment or placed on community control or on felony probation. Once again, this court, as well as this jury, received testimony, not only by virtue of receiving certified court-rolled prints, a certified copy of conviction as business records, but also received the testimony from our crime scene tech who conducted the fingerprint analysis and determined that Mr. Wilson was in fact one and the same of the individuals who was convicted of 2 felonies, that being trafficking in stolen property and false information to a pawnbroker on the 18th of September of 2019. That was less than a month before these murders occurred. That was established beyond and to the exclusion of every reasonable doubt, and the jury concurred unanimously on both of those. Capital felony was especially heinous, atrocious, and cruel. Judge, this particular factor screams for justice. The homicides by which Ms. Melton and Ms. Ruiz died at the hands of Mr. Wilson sets this case apart from normal capital felonies because, once again, it's conscienceless and it's pitiless. And it's unnecessarily torturous to both Ms. Ruiz as it was to Ms. Melton. You heard about the fingernails being broken, the many bruises to their body, of the face, the swollen eyes, the contusions, the bruising all over the torso and arms, the hemorrhages on both sides of their neck, the scalp bruising, the contusions to the lungs, contusions to the liver, to the back of the bladder, to the colon. Her brain was swollen. That was just Miss Melton. And then we have Miss Ruiz. She had the fracture of the nasal bone, the laceration to her left breast, her bruising on both sides of her body, the bruising on the back of her left forearm and on the back of her left hand, the fracture of her fourth finger, the bruising on her right arm, the contusions on her upper back, the hyoid bone, the trachea cartilage being broken, the multiple rib fractures in the front and to the back. And then we have the hemorrhage on the back of her neck. And then you couple that with the fact that Mr. Wilson went ahead and placed his hands around the necks of both of these women and allowed their lives to slip through his fingers when both of them knew they were going to die. The jury found that particular factor, Judge, unanimously as to both Miss Melton and Miss Ruiz, that it was heinous, atrocious, and cruel. He overpowered them, he controlled them, he silenced them by placing his hands around their neck. Judge, we submit to you that factor should be given extremely great weight. And lastly, Judge, the aggravating factor of it being cold, calculated, and premeditated. The jury found, beyond and to the exclusion of every reasonable doubt, unanimously, that this aggravating factor applied to Ms. Diane Ruiz. That evidence that was presented, beyond and to the exclusion of every reasonable doubt, you heard and was corroborated by the evidence in this particular case, the statement that was given by Mr. Wilson himself. He asked her where the high school was and if she could show him. He said that once he got her into the car, they'd drive to the school. He was going to drop her off, but he knew in his mind he wasn't going to do it. He started choking her because she started to get out of the car. You could tell that she was getting scared. He saw the fear, and then when she would not die, he pushed her out of the car and repeatedly drove over her and then attempted to dispose of her body in an empty wooded lot. Judge, that is what is precisely the sort of heightened premeditation that's contemplated by that specific factor. And we would submit to you that that particular factor also carries great weight. The mitigation that defense counsel has presented to this court, we would argue, counts for little weight. Not only that, but it's contested, Judge. It's controverted. Everything defense counsel has presented on behalf of Mr. Wilson, whether it be head injury, whether it be psychological issues, whether it be, family matters, all of that has been controverted. It has not been substantiated. There was no history of brain injury. It's not documented in any of the medical records. You heard here today Dr. Rubino's testimony. You heard counter testimony from Dr. Coyne. All of his scans were normal. Neuroimaging studies, both pre and post-arrest, indicate normal brain scans, although he'd have you believe that he had injuries to his brain. That is not anywhere in the record. As much as he'd like for you to believe it to be so, it is not. The review of the incarceration medical records do not indicate any type of cognitive problems whatsoever, Judge. You heard testimony by Dr. Eisenstein. That was controverted by Dr. Herkoff. Dr. Eisenstein even went so far as to present evidence as related to the Dallas-Kaplan, function system. He tested averagely, Judge. He wants to talk about references to his memory, talking about that he has issues with short-term memory. That's not true. He has an ability to recount events when he wants to. He has an ability to tell stories. He has an ability to make you believe something that isn't true. And interestingly enough, Judge, the neuropsychological testing results are not consistent with any type of neurocognitive disorder. Even Dr. Eisenstein's own tests established that the defendant's executive functioning, the frontal lobe capability, to be within normal range. Judge, you haven't heard anything in this particular case as far as any sort of mitigation that would outweigh any of the aggravating factors in this particular case. The aggravating factors should be accorded such great weight, Judge, that they were proven beyond and to the exclusion of every reasonable doubt as to counts 1 and 4 in the indictment as specifically found by this jury. They, Judge, support and are sufficient to warrant a sentence of death. And they are not diminished by the mitigating circumstances and are sufficient to warrant a sentence of death. And as such, Judge, the state would respectfully request this court to recommend and impose the sentence of death upon Mr. Wilson, because not only is it deserved, but it's earned. Thank you.
Anything else? All right. So this will conclude the Spencer hearing unless there's any other testimony or evidence that either side would want to present, especially the defense. Procedurally, my understanding is that we would take a recess at this point and then come back, and at that point that the state would want to present victim impact testimony or no?
Your Honor, I've spoken with the victim's family, and they would like to rely on what was stated at the actual trial.
Okay, so then this would be the final opportunity for the defense to present any other mitigating circumstances for the court to consider prior to coming back and issuing a sentencing order. Is there anything else that you want to?
We have nothing else, Your Honor. Thank you.
All right. And Mr. Wilson, again, your opportunity, if you wish to address the court, you may. No one can force you to. No one can force you not to. Is there anything you would like to address with the court? Okay. Then we will be in recess. It's 2:20 now. I'm going to spend some time on the sentencing order. So we will come back here at 4 o'clock. And I'll present the sentencing order at that time. Oh, another question before we go. I apologize. I know the state presented a written sentencing memorandum. Did the defense, I know you presented orally your
Right,
sentencing arguments. Was there
Right.
anything else in writing that you
No,
wanted
sir.
to present?
Thank you.
All right. There was a PSI done. Did you all receive the pre-sentence investigation report?
Yes, sir.
Okay. And for sentencing purposes, I know that there were other charges that the jury found the defendant guilty of. If you would prepare any statutorily mandated fines, fees, or costs that are associated with those charges, do you have that? If you don't, that's okay.
I can't recite those, Judge. That's not a problem. I do
Okay.
have a score sheet as it relates to those additional charges as well.
Very well. Have you shown that to the defense?
Yes, Judge, I have.
Any objection to that?
No, sir.
I'll accept that.
Thank you.
All right, if there's nothing else for the court to consider, then we will recess, and I will prepare a sentencing order and come back here, said what, 4 o'clock.
Thank you.
We'll be in recess.
once that